There's a major storm brewing in the world of gun laws, and it's heading straight toward the United States Supreme Court. At the center of it all, a direct challenge to the National Firearms Act and its long-standing rules on short-barreled rifles, commonly known as SBRs. What makes this situation even more interesting is a new piece of legislation that just dropped nicknamed the Big Beautiful Bill, which effectively reduces the federal tax on suppressors and short-barreled rifles to $0. With that change in place, this legal battle may be heading in a completely new direction. So, let's break this down. Right now, a key court case has reached the highest legal stage in the country. It's called United States versus Rush, and its goal is nothing short of wiping out the National Firearms Act's rules on short-barreled rifles. The argument? That these restrictions fly in the face of our Second Amendment rights. On top of that, the petition is asking the court to finally resolve the mess in the lower courts when it comes to what kinds of firearms are actually protected under the plain text of the Constitution. Here's something worth noting. The previous administration under President Trump has decided not to respond to the case, at least not yet. The Solicitor General said, in essence, "We'll wait to comment unless the court asks us to weigh in." Because of that move, the Supreme Court has placed the case on the agenda for a closed-door conference scheduled for the 29th day of September, which kicks off the court's next term. But everything might be shifting now, thanks to the fresh legislation Congress just pushed through. That new law combines elements from both the Hearing Protection Act and the Short Act, and eliminates the tax stamp requirement by dropping it to $0. That's a major shift, and it could potentially change the trajectory of United States versus Rush in a big way. This legal environment is evolving fast, and anyone following Second Amendment issues will want to pay close attention. Now, for those who haven't been following every detail, here's what got us here. Mr. Rush has been hit with federal charges for allegedly having a short-barreled rifle that wasn't properly registered under the National Firearms Act. His defense is clear. They claim the NFA's registration mandate violates the Second Amendment. They've taken that argument all the way to the Supreme Court and are asking the justices to strike down both the NFA and the laws regulating SBRs as unconstitutional. The core issue? Whether the Second Amendment protects an individual's right to own a short-barreled rifle that's commonly used for lawful purposes, even if it isn't registered with the federal government. Backing this petition, the National Rifle Association points out something crucial. Since the landmark Brewing ruling, lower courts have been all over the place when trying to apply the Supreme Court's guidance. The meaning of bearable arms is once again front and center. This case presents the perfect opportunity for the Supreme Court to step in and set the record straight, especially when it comes to determining which types of firearms fall under the Second Amendment's protection. Even though this lawsuit focuses on short-barreled rifles, it could have ripple effects across multiple legal fronts. It could influence challenges to bans on popular rifles or detachable magazines, for instance. The NRA argues that the Second Amendment applies to all firearms that are capable of being carried, and that absolutely includes short-barreled rifles. These aren't rare, obscure guns, they're quite common. In fact, according to the NRA, there are over 532,000 registered short-barreled rifles legally owned by civilians across the United States. Yet the Seventh Circuit Court dismissed this fact as irrelevant, which the petition strongly disputes. Meanwhile, Solicitor General S. John Sauer, speaking on behalf of the federal government under the Trump administration, told the justices they won't respond unless explicitly invited to do so. Not long after that, the court confirmed that the case would be reviewed during a private conference on September 29th. Still, even though it's on the calendar, the justices might request more information or additional written arguments before moving forward. All of this started before the new law, what's now being called the Big Beautiful Bill, was signed. But now that it's officially passed, the legal terrain has changed dramatically. For a while now, gun rights advocates in Congress have been trying to eliminate the NFA's restrictions altogether, While the full repeal didn't get through, cutting the $200 tax stamp down to zero for suppressors, short-barreled rifles, short-barreled shotguns, and other NFA items is still a massive win, and it opens up new doors to challenge the National Firearms Act directly. Gun Owners of America recently joined forces with the Firearms Regulatory Accountability Coalition, Silencer Company, and Palmetto State Armory to file a fresh federal lawsuit down in a Texas district court. And from the looks of it, this is just the opening salvo. More lawsuits from other pro-Second Amendment groups are expected to follow. In this particular case, the plaintiffs are asking the court to rule that the National Firearms Act's registration and transfer requirements for suppressors and short-barreled rifles, now no longer subject to a tax, go beyond what Congress is constitutionally authorized to regulate. Their main point? Since the government is no longer collecting a tax on these items, lawmakers can't claim taxing authority as the legal foundation for enforcing the NFA anymore. Based on that argument, the plaintiffs want the court to block the Bureau of Alcohol, Tobacco, Firearms, and Explosives from applying the NFA to suppressors, short-barreled rifles, and similar firearms. Remember, the entire legal framework of the NFA has always rested on its status as a tax law. If there's no longer a tax, that foundation may no longer stand. So, what does that mean for the United States versus Rush case we've been following? First, the Supreme Court might ask everyone involved to submit supplemental briefs that explain how this new $0 tax impacts the case's core arguments. Alternatively, the justices could decide that the issue is no longer legally relevant and send the case back to the lower courts to be reconsidered in light of this new legislation. There's also a decent chance they just pass on the case altogether and let the lower courts sort it out themselves under the changed legal landscape. Bottom line, the situation is evolving fast and remains wide open. With a tax on short-barreled rifles and suppressors officially erased, other ongoing legal challenges to the NFA may need to be restructured or even refiled. Federal judges across the country are now going to need fresh arguments, backed by updated evidence, to address the fact that the tax provision at the heart of the law is no longer in effect. We'll be watching closely to see how all of this plays out, not just in the Rush case, but also in other important cases like Peterson versus Garland, the suppressor case currently being considered by the Fifth Circuit Court of Appeals. Another big unknown is how the Trump administration's legal team will react if the Supreme Court asks for a formal response. They might argue that the NFA's registration framework still passes constitutional muster, but at the same time, they may finally admit it's time for the court to clarify whether short-barreled rifles and similar firearms are protected arms under the Second Amendment. That's a question that's been lingering for years and continues to split courts across the country. So yeah, things are moving fast. This new $0 tax has changed the entire conversation, and the ripple effects are just starting to show. I'll keep you up to speed as new developments roll in. In the meantime, you can help support the channel by hitting that subscribe button and checking out armscholar.com. We've got free legal resources, gear, merch, and daily firearm deals waiting for you there. And don't forget to swing by our new YouTube page, The Arms Scholar Armory, where we cover everything from gear reviews to live fire range footage. Thanks again for watching. Be sure to like, drop your thoughts in the comments, and subscribe, and always remember, this nation was built by armed citizens who knew their rights, and it's going to be defended by those who still do.